Welcome back. This is part 6 of this video presentation series. My name is Markus Wesaw, and I will be your facilitator for this video presentation entitled, What is OSHA? An Introduction to Health and Safety. If you have any questions regarding this material, feel at liberty to contact me using the information provided on the screen. Although I have found many employees to be quite intimidated during an OSHA inspection, employees and their representatives, such as a labor union official, have a legal right to participate in an OSHA inspection. This is not an absolute requirement and is voluntary for the most part. However, an OSHA compliance officer may ask to interview employees about the workplace, their experience, observations, and whether or not they believe a safety or health hazard exists in the workplace. Employees who do not want to participate in an OSHA inspection are generally allowed to forego or forbear this right. For those employees who do want to participate in an OSHA inspection, a private meeting can be held with an OSHA compliance officer without undue influence. Employees may also point out hazards, describe injuries or illnesses, near misses, and any other safety-related hazard in the workplace. OSHA inspections are public information, and employees will have access to any inspection results, abatement measures, or any corrective action items. An employee may even object to a date set for an abatement of the hazard if they choose to do so. One of the biggest fears an employee has is the termination of employment. OSHA strictly prohibits any type of reprisal or retaliation against an employee for exercising his or her rights under the Occupational Safety and Health Act of 1970. The general premise of this right under OSHA regulations is that employees should not be subjected to any type of fear or punishment because of the desire for a workplace free from known and recognized hazards. Furthermore, workers have 30 days to contact OSHA if any reprisal or retaliation for exercising safety and health rights has occurred by their employer. Again, I want you to start thinking about health and safety in order to get into an awareness mindset. Here are a few questions you can ask yourself. What does a safety data sheet tell you? What rights do employees have pertaining to reporting injuries and illnesses? What are some common safety training topics pertaining to most workplaces? Use these questions to acquire a deeper understanding of the spirit of safety and health regulations. According to the Occupational Safety and Health Act of 1970, employers have the following responsibilities: to provide a workplace free from known and recognized hazards and to comply with OSHA standards and regulations, to provide employee training required under the OSHA standards and regulations, to keep records of injuries and illnesses, to provide medical exams where required under the OSHA regulations, and to provide workers access to any exposure or medical records, to not discriminate against workers to exercise their rights, to post OSHA citations and abatement verification notices, to provide employees with personal protective equipment at no cost to the employee except where the personal protective equipment, or PPE, is personal in nature. Employees should respect that every employer has these responsibilities under the law. It is implied that employees will take part in their own welfare, health, and safety by reporting recognized hazards found in the workplace, promptly informing management of any injury or illness, attend training, and engage in safe work practices required by the employer, be seen as needed for occupational health exams, and where the personal protective equipment provided by the employer when, where, and how it is required to be worn. It is incredibly important that both employees and employers understand that safety and health is a two-way street. More to the point, health and safety initiatives under the OSHA standards requires a strong commitment from management and employees alike. No organization can succeed in safety and health without management and employee commitment. Employers are required to keep records of injuries and illnesses. We have already reviewed the OSHA 300, 301, and 300A forms. However, I thought it would be helpful to review a short employer checklist of the reporting and recording requirements. Employers must report every worker fatality, report each incident or event that hospitalizes 3 or more employees, maintain the injury and illness records, or simply the OSHA 300 logs, inform employees on how to report an injury or illness to management, make all records available to employees pertaining to occupational health and safety unless otherwise restricted, allow OSHA access to records when requested, post an annual summary or OSHA 300A form outlining the injuries and illnesses between February 1st and April 30th for the preceding year. Although there are numerous other employer requirements, this checklist presents a very basic summary of what is required by OSHA under the current regulations. We have already discussed the OSHA 300 logs in depth, but I would like you to reference handout number 6 anyway. Try to identify trends of the workers that are getting injured or who have fell victim to an illness. Look at the types of injuries and illnesses that are being reported for the given year, and what jobs, job descriptions, or departments are most affected by employee injuries and illnesses. All of this information can be of use to any employee who wants to know how and why people are getting hurt on the job. Employees who know and understand this information can use it to prevent their own injuries and illnesses, as well as to help their colleagues in the workplace avoid the same. In general, every employer must provide and pay for personal protective equipment, or PPE. Employers do not have to pay for PPE that is personal in nature. There are 2 items that OSHA has considered personal in nature. Steel-toed boots and prescription eyeglasses have been considered by OSHA to be PPE personal in nature, and as such, the employer does not have to pay for these items. Therefore, the employee would have to acquire steel-toed boots for jobs that require that particular type of personal protective equipment. Not everyone will wear prescription eyeglasses, but for those who do, the employer is not directly responsible for this cost, although in the event side shields are required, the employer would provide those at no cost to the employee. I have visited many employer locations and have discovered on numerous occasions that employees lacked personal protective equipment altogether because the employer thought it was expensive. In other cases, I have observed that employers required PPE to be used at the workplace, but forced employees to acquire and purchase the PPE at their cost. In both of these scenarios, we see a definitive lack of understanding of this important OSHA requirement. If an employer determines that PPE is necessary and required for employees to conduct their regular work duties, then the employer must provide and pay for that personal protective equipment, except for that which is personal in nature. This regulation has been fully implemented since May 15, 2008. Employees working for employers who do not follow this regulation should bring this to the attention of management immediately. In the cases where an employer refuses to pay for personal protective equipment, I believe the best recourse would be to file a formal OSHA complaint. Let's keep safety in mind and attempt again to maintain our awareness by asking ourselves a few questions for review. What are some of the responsibilities of employers relating to OSHA record keeping? What section of the Occupational Safety and Health Act prohibits employers from discriminating against workers for exercising their safety and health rights? Well, since I really didn't focus on this, the answer is Section 11C. So there's a freebie for you. What are some examples of personal protective equipment that employers must pay for? What types of PPE can be required but considered personal in nature, and so the employer doesn't have to pay or provide it? Be sure to reference the various handouts to reinforce the learning process. You have now reached the end of this video presentation. This presentation has been produced by MW Consulting LLC. Feel at liberty to contact us directly. Thank you.